you so much, and welcome to today's presentation, everyone. This is Trends in the Lateral Market Impacting the Timing of a Lateral Move. And this is episode 2 of Financial Poise's series, Ethical and Other Issues in Lateral Attorney Movements. If you'd like to read more about Financial Poise, you can check out the presentation at slide number 44. I'd like to introduce our esteemed panelists today. I'm going to move in alphabetical order. First of all, Dan Binstock from Garrison and Sisson. Next, I'd like to welcome Jennifer Gilman from Gilman Strategic Group. And last but certainly not least, Gary Miles from Miles Partner Placement. For those of you who tuned in to episode number 1, Amy McCormick cannot be with us today. But we are certainly hoping that she'll be able to join us for episode number 3. My name is Tina Solis. I'm a partner at Nixon Peabody LLP, and part of my practice focuses on professional liability in connection with lateral moves. You can see all of our names on slide number 5, and I'm certainly not going to waste your time and read through our bios. But if you would like to look up additional information about any of the panelists today or myself, certainly check out our information and our bios on slides 37 to 41. About the slides today, and if you've joined us from prior episodes, you know how this works. But what we're going to do is, this is not a session in which it's an infomercial and I'm just going to read everything off the slides. The content here is what's important. It's the Q&A that I'm asking the questions to the panelists, and it's their responses. So for those of you who may be listening to this as opposed to watching it on a webinar, don't worry about it. The slides are not critical. It's the content and the Q&A that's important. So I will try to point out if we're dealing with content that's in a slide, I'll point out where we're at, but the slides are not critical. Before we get started, I want to remind everybody, this is episode 2 of a 3-episode series. Episode number 3 is going to be airing on October 24th, and we will do a deep dive into the lateral offer process and some of the issues that need to be considered when negotiating an offer. So strongly encourage anyone who's interested in that topic and considering a lateral move to join us on October 24th. Now, before we get started, I want to thank the sponsors of today's webinar. The sponsors for this session are Mood, the nation's premier online retail cannabis dispensary. And you can get more information about Mood on slide number 2. Also, Sunburst Digital, maker of Type to Learn, the #1 typing application for children in K through 12, as well as Max Asset. If you need to conduct an online auction, Max Asset is your turnkey solution. If you need to read more about Sunburst Digital or Max Asset, please check out their information on slide number 4. And finally, it's my job as the attorney today to note that there's a disclaimer at slide 3. I'm not your attorney, you're not my clients, and you must know that we are here today, along with the panelists, just to provide general education information. To the extent you have any specific questions, please retain counsel and do not act without first giving the specifics of your situation and getting advice to counsel. So, having said that and dealt with the housekeeping issues, I want to dive into our topic for today. I'm going to advance to slide number 10. Let's set the stage. Where we picked up from episode 1, we covered the process in general. But now you're a lateral partner, you've received an offer, maybe even more than one offer, And in addition to negotiating that offer, which we'll discuss in episode number 3, this episode is all about what other issues have to be considered to determine the best time for the upcoming move. And the answer sounds simple. When I give it to you, it's going to sound simple, but it's a very multifaceted, layered, complex analysis that must be done. And what's the answer? The answer is be familiar with the provisions in your partnership agreement or shareholder agreement, whatever your operative document is, know that document inside and out. Because certain of these provisions, a few of which we'll discuss today, can greatly impact when in fiscal year or the calendar year is the best time for a lateral move. And understanding these provisions can help minimize the amount of money that a lateral leaves on the table and can also minimize and mitigate risk in connection with the move. And that's where you all get to benefit today, because our esteemed panelists have been doing recruiting for years and years and years. And you're going to get the benefit of their experience in connection with all of these issues that we're going to talk about today. So, what are some of the critical considerations and issues that you need to be familiar with? Let's talk about the first one. One of the things that I think is most important is knowing, as a lateral partner who's considering a move, what payments are you entitled to if you withdraw, and what are the timing of those payments? Number one, are you going to forego any payments based upon when you give notice or when you have your effective withdrawal date? I've seen both situations. I've seen payments that can be forfeited based on when the notice is given versus when the effective date of the withdrawal is. Another thing to consider is, when is the final distribution for your current year? And is it paid in a lump sum single payment, or is it paid in installments over time? And if it's paid in installments over time, when are those paid and in what proportions? Is it 30-30-30? Is it 60-40? And also, when are your bonuses paid? These are all important aspects that need to be considered when determining the appropriate time for leaving. So now I want to turn it over. I'm going to open it up to our panelists to the first question. What have each of you observed in your years of recruiting in terms of how the final distribution or bonus payments can impact the planning of the timing of a departure? Anybody want to jump in on that one?
I can jump in. I hate uncomfortable silences with polite people. So it'll be short. Like you're saying, it all depends on what the partnership agreement says. Most firms, the partnership agreements will be most favorable to the firm, obviously. But what I've noticed, and I'm sure Jennifer and Gary have noticed as well, is that there is a little bit of sometimes wiggle room within these things. It's within the discretion of the firm and depends on the context in which someone's moving, how they give their notice, whether they race to the phone to call clients right away, how well they follow what they're supposed to do, whether they piss off existing partners by doing things. So I think that is one thing that we'll probably obviously talk a little bit more about, but is some of these softer factors that go beyond what's just written in the agreement, because a lot of it is negotiated with people like you when you come in and kind of help to work through these things. But a lot of it comes down to how well are you leaving, and are you burning the place down or trying to burn the place down when you leave in a subtle way. So that's an important thing that I think impacts what can actually happen at the end of the day.
Gary's raising his hand. I saw a lot of nodding of heads there. So Gary, go ahead.
And like to build on what Dan's saying, there is always some element of discretion on behalf of the firm in terms of what they'll yield to. And there's also things that may be going on, at the firm, depending on that it can impact that timing and that discretion and how that discretion is applied. For example, if a firm is struggling and there's been a series of departures, and then you happen to walk in as a partner and say, "Oh, I'm bringing, I've had an opportunity I can't pass up on, and I'm bringing my rather large group to another firm." Depending on how far along in that process of multiple departures, it could impact timing in terms of how strictly firms will adhere to whatever it is in the partnership agreement. The other thing that I thought about, it kind of hit me as a lightning bolt as we were talking about the different things, or as you, Tina, were talking about the different things that partners need to think about in terms of payments that are due. One thing that partners really need to make sure they're aware of in their partnership agreement, because a lot more firms have gone to a mechanism where in previous years, if partners have really performed well, their bonuses, instead of being a straight cash payment, might be a forgivable loan or such, where you might, depending on when you leave, have certain, bake yourself into certain clawback provisions. And so you really need to be understanding of the totality of how your firm's system has worked, what the partnership agreement says, what your standing is, like Dan was talking to at the firm, and what your relationships are like, because that can impact greatly when you want to make announcement, when you can expect to be able to get out of there, regardless of what the actual, period of notice is, et cetera. So, you want to think of this as a 360-degree understanding of what your departure means within the context of your partnership agreement, your relationships at your firm, and how the firm is dealing with departures in general.
I think both of you make great points. Dan's point, you need to be a good firm citizen when you leave. You need to leave the right way, right? You need to make sure that you're working cooperatively with the firm. You need to be mindful of your client deadlines, but be a good firm citizen. That always helps. I've seen it time and time again. And Gary's point is also well taken. And I think you need to understand the larger context of what's going on at the firm at the time. I think that just further reinforces the timing aspect of this. I mean, you may want to leave and you may say, well, I'm not, I'm 9/12 of the way, 3/4 of the way through my year. And so maybe it's better if I leave at year end because I'm going to get those true up payments, but it might be better for the firm as well. And so I think all of that goes into it. And again, it just shows what a layered analysis this has to be, because it's not just the hard factors of what's in the partnership agreement or, your specific employment agreement. If you have a side agreement, a lot of firms are going to that. As Gary mentioned, a lot of people are using, forgivable bonuses, so to speak, where it's a forgivable note in connection with that bonus. So it's not just knowing the hard factors in the documents itself, but it's knowing the soft factors and being cognizant of those soft factors. So I think those are excellent points. And Jennifer's raising her hand too. So
well, Gary was so polite. I wanted to be polite too. I would say, just overall, a lot of the partners that I speak to don't know the specifics of their partnership agreement or the timing of the payments. They may know what their firm's fiscal year is, and they may know that they're owed a payment if they stay until a certain date, but sometimes they don't realize it's not paid out in a lump sum, it's paid out over time. And sometimes they feel a little too trapped by the idea of the fiscal year. I always tell them if they're unhappy and they want to be somewhere else, as long as they understand the money that they're leaving on the table, we can negotiate to make them whole in some way. But sometimes they just don't know until a little bit later in the process, which isn't a great place to be. So they're much better off at looking at all of their documents before they start having these conversations.
Can I jump in one thing, Tina? Because a lightning bolt just hit me as well. Firms are also, especially the bigger the firms are, and the more they bring people in and lose people, and right, they become more sophisticated about that. Sometimes don't just check your partnership agreement. Make sure you look at your partner manual. Sometimes things are referred to in a partnership agreement and hidden on page 64, paragraph 3, sentence 2, that seems to say nothing that you'd think about the very, very specific issue that's addressed in the partnership agreement is actually hidden, where the details of it are hidden in the manual. So it's just, it's unfortunate that we've gotten here over time, but it is something that you have to spend the appropriate time, with counsel digging in on to make sure that you're not hitting any landmines when
No,
you're trying
I think that's another excellent point. And you're right, the documentation is becoming far more sophisticated. Firms are recognizing, that this is a very competitive field. We've had a very robust lateral market. I think we've all talked about that, and I know our panelists have been the beneficiaries of that, and that's great. But I had a recent situation just a couple of months ago where I was looking at something and I said, well, wait a minute, where's X document? Where's Y document? The partnership agreement refers to those. Have you seen those? And to which I got the response, no, I've never looked at those. Well, we need to, because we can't understand the full picture. So I think those are all excellent points, and I'm going to keep us moving on. It's my job to do that. So another issue that I want to briefly talk about is the return of capital. Now, to be sure, this is an equity partner issue. I know there are a few firms that have, nominal contributions from their income partners, but this is really an equity partner issue. And again, some of the same questions should be popping into your mind if you're a lateral considering a move. And that's, when do I get my capital back? Is it in a lump sum payment or is it installment payments? And I will tell you, the trend now is for firms to pay out over time. Used to be everybody got interest on those unreturned portions, which, made it a little bit easier if you weren't going to get your capital back in full for 3 years because you were earning interest on it. That's now no longer what I would call the typical rule. That's more of the exception to the rule these days. And again, well, the return of capital, like anything else, can sometimes be negotiated depending on, all of those soft factors that I think we just talked about. The point is, read your agreement very, very carefully, because agreements vary widely. And so I want to pose a scenario for my panelists here, because it's something that I'm seeing more and more, and it's something that laterals are faced with. So here's the situation. Current firm pays back the capital contribution over time. Let's just call it 3 years in a third installments, okay? And our lateral partner under this hypothetical has accepted an offer in which the firm is asking for an immediate upfront payment of the capital contribution. Now, we can talk about financing that capital in just a second, but I'd like to open this up to our panelists. If you or someone that you were working with as a lateral candidate was facing a situation like this and came to you and said, wait a minute, I'm in a real cash flow crunch here. how best do we solve for this? Anybody want to tackle that one? Sure.
So I'm actually dealing with something like that right now. I've dealt with it in the past. And I want to preface this by saying that the more a firm thinks of you as a lateral partner in terms of being a high value target, you and your group, the more natural leverage you will have to be able to negotiate some sort of solution to these types of problems. Okay. And, I've seen firms sometimes work out, delayed capital payments, right? Like, okay, we're gonna, we'll break it up. We'll let you pay it in over, couple of years. There's also the possibility, if it hasn't already been made part of the equation, additional sign-on bonuses that maybe creatively get paid back when the capital comes in. Like, there's a lot of different ways to navigate that where it's not illogical on either side of the equation. And what I tend to do in these situations is, depending on how the process has gone, these are exactly the type of situations where you really give the firm, even before you join them, if you address it directly with the right person, prospective new partner to firm leader, or, set of, firm advocate, firm leader, etc. You really get to kind of show them how you are going to act as a partner, and look for how they are going to treat you as a partner. And sometimes that's really appreciated, quite frankly, in a firm acquiring a partner and or group, etc. So the best thing you can do, and this is kind of what Jennifer talked about, is the more you can think about these issues on the front end, make your hopefully trusted professional advisor, like those of us on this panel, aware of what your concerns might be around this. People like myself, Jennifer, Dan, we may ask you early in the process, but not every recruiter will. And the better communication you can have there, the earlier you can address some of these issues in process, the better chance you have for a mutually agreeable solution to what can be a pretty scary, difficult, situation, especially if it's just dropped on everyone late in the process. So I think that can be important.
Yeah, I agree with that. I think there are a lot of firms that aren't going to just say, oh, you don't have to make a contribution, right? And they're not going to be able to wait 3 years because they're setting a precedent for everybody else. But if you know ahead of time that you're going to have a cash flow issue and it's going to be a while until you get your contribution from the firm you're exiting, you can arrange for a sign-on bonus and financing and a schedule and do all the things that they might be able to be a little bit flexible about, so that it makes it palatable for you, so that you can say yes to that offer.
Yeah.
I think that's good points. And Jennifer, you mentioned financing, and I'm seeing that more and more, where with some of the larger firms, they will say, here's our 3 preferred lenders, and we've got a special deal with these lenders, and here's the contact information. And so I think those are very well taken points. And the takeaway, again, know what the issues are that are particular to your situation, and know what's in the partnership agreement and all of the documents, and plan early, right? And good communication. Because again, for anyone who's contemplating a lateral move, talk with your recruiter. I mean, you've got the benefit of some very sophisticated individuals on this panel, and have great communication with your recruiter because he or she's there to help you, but they can't help you if they don't know about the issue. So I think got some great answers there. Okay, let's
And
move on
probably
to,
consult someone like you, because some of them, even when they consult with us and they look at their agreements, need an expert who can look over the agreements with them.
Can I ask one quick question, Tina? I know timing is important, but this is a simple thing. When a partner says, I don't know, I haven't seen my partnership agreement since I became a partner. How do I get my partnership agreement without raising flags? I'm curious to see what you all, because I think we're assuming everyone has easy access to their partnership agreement. And sometimes firms will track who downloads their partnership agreement. And so if they don't have a paper copy somewhere that they can look at easily, it's a pretty sensitive document. So I'm curious as to, if people don't have it, the best way to get it. One of the things that I've always said is, you know, you're meeting with the financial planner, you're going through all of your assets, obligations, and everything. You're doing a whole holistic financial summary. And part of that is your assets in the firm, what's your liabilities and things like that. That's one way to couch it that I found has been helpful, whether they see through that or not, now that we've said it on here. But I'm curious if anyone else has any sort of tips on getting access to that if it's not available or
I
readily available.
I will tell you, Dan, your recommendation is consistent with what I typically tell folks is to ask for it under that context. And, some firms really protect it. I mean, it can't be downloaded, it can't be printed. Other firms, it's on the intranet. And so it's a little bit more accessible. But I do think it's difficult because, and again, this is why planning ahead is so important in my view, because what often happens is you're in the thick of it, right? You've got your offer and you're thinking, oh my goodness, now I have to figure out what my partnership agreement says. No, the very first thing that you should be thinking about when you're contemplating a lateral move from my standpoint, because it's the first thing, if you call me and say, Tina, are you going to represent me? The first thing I'm going to ask you for after I've cleared conflicts is, where's the partnership agreement? I can't do anything until I have that as my starting point. So for anyone who's contemplating a move, think about the partnership agreement first. How can I get my hands on it? Where can I look for it? And I will tell you, I've had situations where a lot of folks that are thinking about it know somebody who's left in the past and have gotten it from someone who has a copy of it who had left in the past. So
that's also a really good resource just on knowing what your firm's going to do or handle things, is talking to other people who've left within the past 12 months, saying, what did they do to you? How did they handle this? How much did they push back on this provision and things like that? So that's a very fertile source of good intelligence on how the firm will respond to certain provisions in their partnership agreement, with the caveat that every situation's different and they may not care if it's partner that's got, not much business versus someone who's bringing a whole group. Could be a completely different response.
But to your earlier, sorry.
No, Jennifer, go ahead.
To Dan's earlier point, if you're a good actor in the leaving, you may be treated a little bit better than some of the partners who left in the last 12 months who didn't handle it quite as well.
And I think the other thing that we have to remember from a legal perspective, you owe a fiduciary obligation to the partners in the firm. You are entitled to have it. And so as a matter of law, you are entitled to have a copy of that document. So I don't want to, I understand we don't want to raise any red flags, but just as a matter of course, you are entitled to have that. So I would recommend even partners not considering a move, that should be at the top of your list to make sure you have a copy of in your desk file is your partnership agreement. Okay, all great comments. Keep moving forward. And I think this is another important one to talk about, which is a clawback provision. Because based on what I've seen recently, clawbacks are being used more and more frequently. And what is a clawback provision? For those of you who may not be familiar, it's a contractual provision that requires the return of money that has been paid out under certain circumstances. And I'm going to open this up to our panel in a second, but where I'm seeing it is in the equity partner situation. Equity partners are paid draws. And what does that mean? That's not salary, that's not guaranteed. It's an advance on an equity partner share of their year-end firm profits. And so depending on when you're thinking about leaving, you may be over distributed because typically draws are paid in 1/12 of the year, once a month in 1/12 increments. If you leave early on in the year, you may be over distributed, meaning you've been advanced more money than the net profits at that time of the year show. And so what I'm seeing is firms are starting to say, you need to pay back the delta of that over distributed amount. And so I'm seeing this, but I'm interested to hear from our panelists. Are you seeing this? Is this becoming more commonplace in placements that you're doing, or do I just seem to be getting the one-offs here in the unique situations?
Gary, you look like you're ready to.
Well, it's interesting because actually, and I don't know how the other panelists have seen this, you may be getting the one-offs because I feel like after 2009, most firms, large firms, really started unequally or less equally distributing their budgeted compensation or draw, right? And back ending as much of it as possible, carrying, and it's related to some stuff we were talking about before, carrying over into the next quote unquote fiscal year, the final true ups and payments into and extending that out, right? Like, I can name 10 firms off the top. I won't, but I can name 10 firms off the top of my head that distribute, fiscal year A or this fiscal year's, true ups and bonuses as far into the next year as like June, and so I've seen a lot more draws being, a much less significant amount of the budgeted comp, particularly for equity partners. Sometimes it's different in firms that are situated where folks are shareholders, and like it can get, you can see, various differences. But I now that being said, I'm absolutely seeing attempts at clawing back anything a firm thinks they can potentially claw back. And we were sort of discussing this early before we got on with everyone, but under the amorphous clause of conduct unbecoming a partner, if you were preparing to leave some, clawbacks are definitely a part of the everyday move now. That firms are trying to figure out how much they can salvage when someone leaves, whether it's keeping certain amounts of capital, whether it's, all the things that Tina has to fight over when she's representing partners leaving their firms. But yes, whether it's over distributions, underperformance, at a certain point, measured up to a certain point in the year. So we've over distributed you that way. Yes, clawbacks are definitely part of the mix.
Jennifer, you've been nodding your head.
Oh, I agree very strongly with Gary. I've seen firms paying a lot less than 100% during the year, so that if a partner has a bad year, or if we want to increase retention, there's a bigger payment toward the end. But Tina, I was wondering, in terms of clawbacks, do you ever see people set that off against the return of capital contributions?
So, and again, I told you we were not going to read from the slides, but this is the perfect segue into the next slide. We were going to talk about setoffs. And Jennifer's right. I have seen situations where, whether it's, the conduct unbecoming that Gary referenced, or it's outstanding account receivables being set off against the capital account. I have seen situations where law firms have, in a few instances, attempted to do that. Now, that raises the larger question, which, we're going to get into in a few minutes here, about the enforceability of these provisions. And I'll talk about that in a minute, but I'm certainly seeing the clawbacks, especially in the bonus arena. I'll give you an example that I shared with our panelists before we got on. I had a recent situation in which someone called to retain me, and I looked at the agreement, and the agreement talked about the firm's ability to claw back a bonus if in fact you were no longer at the firm. Now, there may have been some ambiguity there on what did it mean to be no longer at the firm. Did it mean you had given your notice of resignation, or did it mean you had effectively withdrawn? Because in my mind, there's a legal distinction there. Giving a notice of resignation is different than the effective withdrawal date, unless management is going to accelerate that. So the day you give notice of resignation is your effective withdrawal date. But, I looked at this and thought, this was someone who had already given notice, and thought, boy, if they would have called me 10 days earlier, there was a simple solution. I would have just said, don't give your notice yet. Then we don't even have to get into the ambiguity of this provision. I would have just said, hold on for 2 more weeks, that bonus is going to be paid, and then you can give your notice of resignation after the bonus has been deposited and clears. Because the way this agreement's written, there's certainly, the firm has an argument, they're not going to pay you that bonus because you've already given your notice. So I am seeing that, and those are some of the things that we have to work with the law firms on. But I think all of these comments, again, are just reinforcing, you've got to know the issues out there. You've got to know what your agreements say, and you've got to leave in the right way. Because to Gary's point, I think firms are far more willing to really look at that conduct and say, listen, if we don't think you're leaving in the right way and consistent with your ethical obligations, we're going to use our documents, and we may apply a set off, or may try to claw something back.
And sometimes it just gets very like, look, if you don't take so-and-so, leave this person here to service these clients, we'll let you go. Although, you're not supposed to do that, they're sort of unwritten, like if this person's hands off, or you're not going to do this, or, there's some horse trading that goes on behind the scenes.
That's right. I think that's absolutely right. Okay. All right. We've talked a lot about clawbacks. Setoffs are another type of provision that sometimes you see, where it allows one party to deduct an amount it owes from what is owed to the other party. So I think this was Jennifer's point just a few minutes ago, which is, you can set off from those capital accounts if a firm thinks that you're doing something contradictory to what's in the partnership agreement. And so you need to be cognizant of that. And then also forfeiture provisions. And a forfeiture provision, for those of us who are listening or watching today and are not familiar, is a provision that provides a party in a contract that they may lose something to the other party under certain circumstances. And so I've seen situations where you can forfeit a percentage of your capital or your bonus, or even profits in the firm, if, for example, you leave to compete within a certain geographical distance. I will tell you, non-competes are not enforceable, but they still, you see them from time to time in partnership agreements. So I want to talk a little bit, and I know we've got about 20 minutes left, so I'm going to jump ahead a little bit, but I want to talk about the enforceability of these types of financial disincentive provisions really quickly before we get back to some questions for the panelists. All these things we've been talking about are what's known in our area of the world in the law as financial disincentive provisions. And what are they? They're provisions that provide that a departing partner's deferred compensation or equity interests will be reduced if the partner competes with the former firm or leaves under certain timing circumstances. And the purpose is to discourage competition through penalties and to compensate the firms for their financial losses when partners depart. Now, the big question for everyone who's watching today, I think, is, are they enforceable? And the answer is, it depends on where you reside. The courts are split. The majority of the states in this country say that these types of provisions are not enforceable because they restrict a departing partner's right to practice law and they impact the client's right to select the attorney of his or her choice. There's also tension with these types of provisions and the model rules. There's tension there because the model rules provide that you're not supposed to enter into any type of agreement that restricts the rights of a lawyer to practice after termination of that relationship, except for retirement benefits. So you've got that tension there with these types of provisions that are often found in the operative agreement and the model rules. And so I want to quickly, and this is where the slides are important, show states following the majority view. See some big ones in there. Illinois, Massachusetts, New Jersey, New York, Texas, they all follow the majority view and say these types of provisions are not enforceable. But I want to show you the majority, or excuse me, the minority states that follow the minority view. There's probably one on there that everyone's scratching their head about. Maybe more than one. I will tell you, I certainly was surprised when I first started doing this type of law 20 years ago and saw California on there, because California is usually very, very pro-employee, but not with regard to financial disincentive provisions for lawyers. So be very, very mindful of where you office, where you're licensed, because it makes a difference. And so again, this is a complex analysis, and a lot of my clients are licensed in multiple jurisdictions. So we need to work with the recruiter and with the candidate to make sure that they're exiting in a way that comports with the rules of professional conduct in all the states that they're licensed in. So it's not an easy analysis. And again, here's just a couple of the leading cases showing the majority view. Cohen is the seminal case in New York. Stevens versus Roots, Pitts, and Post, Illinois Appellate Court. You'll notice the dates of these cases. Still good law in these states. So want everyone to be mindful of that. And then I want to turn next, and I apologize, I'm cutting this a little short, but as usual, we're running short on time here. I want to talk a little bit about firm notice periods. Because I think oftentimes when laterals are thinking about a move, they think, oh, well, setoffs or clawbacks, those are all financial disincentive provisions. But a firm notice period, well, that's simple. That's just how many days I have to give written notice to the firm before I leave. And oftentimes, I think firm notice periods get minimized a little bit. So For those of you who are new to this world, maybe this is your first time you're contemplating a move. A notice period is probably, besides knowing where your partnership agreement is and what it says, the first thing I always say to clients is, how long's the notice period? I see anywhere from 30 to 60 to 90 days. And a notice period says how many days before withdrawal you have to give notice, who you have to give notice to, and it usually says whether or not management can accelerate your effective departure date. Important for you to know that. But again, there's this tension with the model rules, because the firm may say, well, you've got to give us 60 days to properly transition and notify clients. But we're bumping up against our good old buddy model rule 5.6 that says, well, wait a minute. You can't enter into an agreement that's going to restrict the right of a lawyer to practice after that relationship terminates. What about if there's a conflict and the client says to a lateral, you've got to move. We've got a conflict here. We need you to move. Again, we've got that tension that we've got to be mindful of. And so when you look at the cases that analyze Rule 5.6, I think you would conclude that the majority of them say, listen, let's say you have a 60-day notice period. If you've got a situation where the clients have all been notified, given your notice of resignation, the clients have all been notified, you've transitioned the files that are staying, and you say, I'm going to help collect on the outstanding AR, they can't hold you for those 60 days because that's restricting your right to practice. And more importantly, the client's right to choose his or her counsel. And so again, I would encourage those of you that are thinking about notice periods, read ABA Opinion 489. It specifically notes if a notice period would affect a client's choice of counsel or serve as a financial disincentive to a competitive departure, it may violate Rule 5.6. And they may not be able to hold you for that full notice period. And again, slide 25 talks about some of the cases that have looked at Rule 5.6, maybe not in the notice provision context, but certainly in terms of financial disincentive provisions, and have not upheld those. So when you're thinking about a notice period and how it can impact the timing of your departure, a few things that you need to think about. Number one, your client's needs and the deadlines have to come first. Remember, when you're making a move, the client's needs always come first because of your fiduciary obligation to those clients. Now, a couple of other things. We talked about, well, what if the firm holds you for the full period? You got to think about how that could impact your timing. But then you also have to think about, wait a minute, what if I gave notice and the firm says, okay, thank you very much, Tina, for giving notice. You're out at end of day today. Have you made the plans? And are you ready? And is the new firm ready for that? So you have to plan that you're going to be held the entire time, but also plan and make sure you're ready if they let you go and release you immediately. Again, you've got to plan ahead. Talk to your recruiter, make sure the new firm is aware of all of this. If you have counsel, communicate, because it can greatly impact the timing. So I've talked a lot. I want to talk to the panelists in terms of what they've seen and what they're seeing in the marketplace in terms of how long are firms holding candidates these days? What are you seeing?
It's all over the place from my perspective. Sometimes they want someone out quicker. Sometimes they want a client, or they want to keep them for a longer time because there's a very active matter and they're big accounts receivable, and they're worried that if they leave before the accounts receivable is received, they're less likely to recover it, so it's really all over the place. Depending, it's so situation specific. But the one point, the reason I spoke is that what firms try to say in the beginning and what they will agree to once they have a conversation with that candidate's lawyer who's representing them, there can often be quite a big difference in terms of what is actually agreed on. So I think partners should not always assume that what the firm says right out of the gate is where things should be or will end, unless they have someone representing them where they know enough to know. Because oftentimes there's also the issue of, um, unclean hands. I think why a lot of these cases don't actually, the cases you showed before, 79, 89, and, these 30-year-old cases are because these cases often don't go to trial, one, because of arbitration proceedings, number two, mandatory arbitration, and number two is most of these firms know that they've got unclean hands from what they're trying to prevent their departing partners from doing. They're simultaneously trying to get new partners to come in and violate their own agreements they've got with their other firms. So there really is a lot more play and wiggle room than people may realize, so long as they know which levers to pull and they've got someone knowledgeable in their corner helping them. That's all I've got on that.
To add
Thanks,
to
Dan. Go ahead, Gary.
add to what Dan said, there's 2 points I want to make. Again, and this is where self-awareness about your practice down to the minute detail is really important, because you may have leverage in terms of certain fees to be collected where you can bargain, where you can say, look, you want me to be a good citizen and collect these fees like I've been doing for the last however long I've been a partner? Then you'll, and you don't say it as forcefully, you find a nice way to say it, but you can clearly suggest that, look, we both want the same thing. You want to get your money in, I understand it, but we're having a divorce here, and I want to be able to get to where I need to go and get started on what I need to do to integrate my practice where I'm going. So there are a lot of different things within the day-to-day operation of your practice that might be points of leverage to help you get the release when you want it. The other flip side of it is, again, knowing your value and knowing, and when I say your value, not just your raw dollar compensation to revenue generation, et cetera, where most people kind of think about their value. Know if, for example, if a firm knows they have a partner who's really magnetic that might want to leave, do you think they want that partner in the halls for an extra 30, 60 days talking about how upset they are with how poorly they've been treated after being a substantial contributor over the last however long you've been with the firm? Like, these are the things that keep leadership up at night. And if you know your value, you've done the things in terms of you're working with a really good, experienced recruiter who can advise you properly, you've engaged counsel, you will see and know your pressure points that will help, that you can push, that will help you get a much more amenable, agreed upon, exit strategy. So it comes down to all of that and understanding, and then of course communicating with all parties involved such that you can get the best result. The longest I've seen domestically, I've seen someone who actually stayed. It wasn't my deal, but I know through someone else. Someone actually stayed through a 90-day hold period. And now this was probably a good 12, 13 years ago. And I couldn't for the life of me understand why they did that. Like I'm pretty sure they could have gotten out if they would have had the right counsel. But yeah, that's kind of the longest I've seen domestically. But most people, a week, 2 weeks, you can probably, if you haven't been like a complete, disaster at your firm, you can generally find a way to get out in a mutually agreeable amount of time.
Yeah,
I think that,
the
go ahead,
firms
Dan.
the firms that hold people because of bad blood, frustration, it's such oftentimes it's so emotional and there's so many hurt feelings that to the extent anyone's watching this, it from the laterals perspective, if laterals are trying to come in while their group's being held over, they feel like they're walking into a mess. Like if the firm's trying to backfill people that have left, it just gets at the end of the day, it's like penny wise, pound foolish
Right.
to hold people to the fire unless there's a really strong business reason, not out of resentment, frustration, because it can really backfire in ways that firms don't intend with other partners seeing how the firm is treating the departing partners, and it can get messy, real and it can ripple much more than just that particular group.
And I heard you make the point at the beginning. I had to have this conversation just this morning with someone. You have to understand the firm might give you 30 minutes in one box if
Yeah.
they're really mad. And you have to be prepared and have all the contact information you need and have a plan and know that you have a desk and a computer at the next firm and that you can get going a little bit faster than you thought, because otherwise that's going to be a really disturbing day.
Go ahead, Gary.
I remember a situation, and this was a while ago. I remember a situation where firm that was being departed from called building security literally 5 minutes after announcement and collected all devices and walked partner off premises. And then there's another firm, I won't name it, but there was a certain, whenever an announcement was made, you could tell how valuable you were as a partner, because when you went in and had to announce to the person, they either got up and went and locked the door and sat down and tried to turn you around, or they gave you a box and said, go get your stuff and be out by, as as Jennifer said, like in half an hour. So
Some people end
It's
up
happened before, and it also it depends on the individual partner a lot. I moved someone who had seen that happen to one of her partners who had departed, and she was very, very nervous. But when it came time to her, it was very amicable because she was a different person with a different practice who had acted differently. So it is quite individual.
I think that's right. And, I had a situation, this was a number of years ago, but it was a team and they gave notice at, let's call it 10 o'clock in the morning. By noon, they each had written letters from management saying you're being released effective immediately. And again, they were walked out. Now, because they were smart about this and they had planned ahead, they were able to leave and they knew exactly what to do because we talked about it, and they were able to drive over to the new firm and they were able to effectively start practicing immediately. But I think everyone's always so concerned about, oh my goodness, they're going to hold me the full 30 days or the full 60 days. And I always say exactly what Jennifer said this morning to her candidate. Okay, are you ready? If you come in and you're telling me today's Friday and you want to give notice Monday morning, is the new firm ready to have you? Because the minute you give notice, you may need to call the new firm and say, I've just been released. So again, I cannot emphasize this enough. Plan, plan, plan. Communicate with your recruiter. Communicate with counsel if you've retained counsel. Make sure that you have planned for all contingencies. And I know we're at the top of the hour. I am going to beg everyone's indulgence for just a few more minutes because I have one final topic that I would like to talk about, and I want to get our panel's take on it before we go. And that is, oftentimes you're going to see in partnership agreements a non-solicitation of other firm employees. And the first question from the legal standpoint is it enforceable? And I will tell you, overall, these types of provisions are enforceable. If someone is not a partner, you should not be soliciting them while you are still there. You must wait until after you have withdrawn and you get over to the new firm. But again, the rules in each state vary. And so you should speak to counsel to make sure you're complying. You'll see on this slide, which is slide 32, we have some of the different rules around the country. But what I want to open up, and I want to ask these questions before we finish here, because I think it's so important to hear from our panelists today. When a lateral candidate comes to you and says, listen, I've got a group, and the group's not just partners, right? We are envisioning that we would like counsel. We've got several senior associates or just associates in general. What do you, and I know you're not practicing law, so I don't mean advise in the legal sense, but how do you solve for that problem? And what have you seen over the years? Don't everybody all speak at once.
Well,
I may get in trouble with Tina, but I talk about speaking a little bit hypothetically with some of those people in a way that doesn't skirt the line, and talking with the new firm about the type of support that you're going to need right away to get things done, and describing the people that you're going to want to bring with you as soon as you give notice, and you can go ahead and do that. Gary, do you have something different that you advise?
Well, and I can tell you, this can be an extreme point of consternation internally amongst the team, because if you have a partner or group of partners and they follow to a T, they follow what, the expectation is, and they don't communicate. Oftentimes those non-partner people can feel like they were surprised, something was sprung on them. It can be something that impacts, the internal workings of a team. I, like Jennifer, have always tried to bring this up early in the process with my candidates and with counsel as quickly as we can get Tina involved. But I really do believe that sometimes you have to figure out creative ways to, at least open the pipeline for information in a way where your people can have a sense that there's something going on, even if you're not directly, quote unquote, soliciting them. Recruiters can be very helpful in that regard. The firm you're going to can be very helpful. It may impact exactly when you want to announce, and then activate let the other firm activate and do the recruiting. But there's always that tension that folks that have been working for you, that look at you as a mentor, that are training up under you, if you're not able to share with them that you're thinking about doing something different, and it can get difficult. It can get difficult at the end point of the process, because I've actually seen it splinter some, or shave off over the years teams where, an associate or a counsel felt like, wait, why wasn't I in the loop, right? Like, why didn't you tell me? And they don't always understand the fiduciary responsibility behind it or accept it, right? So this is an issue that has to be thought through with some complexity and sophistication.
The one, I think, I don't want to call it silver lining, is that sometimes it doesn't have to be the partner that initiates the discussion, because the people around them sense that something's going on, and they will ask, are you looking? Are you on the market? Because they can just pick up on what's going on. And so sometimes then it's, how do you respond? And, I can't say anything, but I'll just tell you that if I were to move, I consider you a very important part. And, if there was something I could tell you, I would tell you at the right time, and you just have to trust that I really see you as a really important, valuable part of the team. That's all. And little sort of things like that, but that is the silver lining, that people do often pick up on it before you have to initiate it.
But I think if you don't have that kind of conversation, those non-partners are vulnerable to being persuaded to stay at the firm because the firm acts like they care about them. And look, that guy left and didn't even tell you. And you've got a couple of hours where the firm can get to them.
Or they may be concerned that the partner's leaving. They don't know what that means. They may go on the market, and before you know it, you tell them what's going on. I've just given notice, and they say, well, I've got 2 offers from these other places. And you're like, oh my gosh, I had no idea. So this is where all of this stuff, there's a lot of gray area and tension between the different factors of what's in it for me versus what rules and what's in it for my clients, and what are, all of these different priorities of clients, partnership, then me on the bottom, although it often doesn't feel that way.
And depending on the timing, you may have to get sign-on bonuses for associates or counsel that are leaving money on the table.
Yeah.
And this is one of the reasons. So for all of our audience today, thank you for indulging us in a few extra minutes. But to me, this is one of the thorniest issues, because now you're not just dealing with the partners that are in the group, but you also have to consider, how is this going to impact the counsel that are part of my team, my associates, my practice assistant even. And so again, thank you for all your comments from the panelists. I think again, another great session. But I just think it exemplifies how thoughtful you have to be about this process, how much planning you have to do. And I think you have to work to find creative solutions for these types of issues. And the way that you do that is you work with a well-experienced recruiter, you engage counsel, you work with the new firm, because there are solutions to these problems. And obviously we could talk for another 6 hours and still, I think, debate some of these issues. So I want to thank everybody for joining today. I want to thank my panelists again. Couldn't do this without you, and you always make this a fun exercise. So thank you very much for your time today and taking time out of your busy schedules. I have not seen any questions come up in the chat, so I will ask, going once, going twice. You certainly have our contact information if anyone that's watching today has any questions. Thank you so much, and look forward to seeing the panelists for episode number 3, and hopefully you'll be able to join us as well. Thank you so much.
Thanks, Tina. Thanks, everyone.
Thank you.
Great talking to you.
Bye-bye.
Bye-bye.